Okay, let's unpack this. Imagine you've got essential stuff buried underground. Water pipes, gas lines, maybe telecom
Yeah,
cables.
critical infrastructure.
Exactly. But how do you find them if they're made of, say, plastic? Non-metallic stuff. Your standard metal detector is
Right,
useless.
and that's become a huge issue because plastic pipes are everywhere now.
And the old ways of trying to make them traceable, like taping a wire on or just laying one alongside, they weren't great.
No, definitely not. Wires could break. They might not even follow the pipe properly if it bends.
Or worse, if you tried embedding a wire inside the pipe wall itself, you could actually weaken the pipe. A real headache.
A significant headache.
Yeah.
Lots of accidental damage, delays, extra costs for utilities and construction crews, and finding leaks. Even harder.
So this is where our deep dive gets really interesting today. We're looking at a real legal fight straight from the Delhi High Court documents in India.
Yeah, it's a fascinating clash involving pipe technology, patent law, and how tiny details can just make or break these big money disputes.
We've got two main companies, Dura-Line, who say they invented a better way to make these pipes detectable.
And Jain Irrigation Systems Ltd, a big player who Dura-Line accused of basically copying their idea.
So the big questions for the court were, well, two things, really. Did Jain Irrigation actually infringe Dura-Line's patent and their design?
And maybe even more fundamental, was Duraline's invention actually new and, inventive enough to deserve a patent in the first place? Jain Irrigation definitely pushed back hard on that.
Right. So this deep dive is your shortcut to understanding the tech, the legal arguments, and how the court picked it all apart.
As you said, the problem was finding these buried non-metallic pipes accurately. The old methods, taping wires, laying them alongside, inserting them in the wall, they all had serious drawbacks.
Wires getting damaged, peeling off, deviating from the path, or, like we said, compromising the pipe's integrity. Not ideal.
Definitely not ideal, especially for pipes carrying fluids under pressure.
Okay, so Dura-Line steps in. They say they've solved this with their pipe assembly having traceability and leakage detection features.
And they got an Indian patent for it, IN 1997-22, filed back in 2003, granted in 2007.
So what was the magic? What did their patent actually claim?
Well, the core of it, particularly in Claim 1, which is always the key part legally, was a specific combination. First, a non-metallic pipe for carrying fluids.
Okay, standard enough.
Second, a tracer cable that was co-extruded onto the outer surface of the pipe.
Hold on, co-extruded. What does that mean, and why is that word so important here?
Great question. It's absolutely central. Co-extrusion is a manufacturing thing where you push two or more different materials, like plastics, through the same die at the same time.
So instead of making the pipe and then sticking a cable on later.
Exactly. The pipe and the tracer cable, along with its own protective polymer casing, that's the third element, the cable being encased, are all formed together in one go as the pipe's being made.
Got it. So it's built right in from the start on the outside and protected.
Precisely. And the idea was you could send a signal down this integrated cable, locate the pipe easily, maybe even detect leaks, all without weakening the main pipe structure.
And they called this Dura-Track.
That's the one. That specific setup, co-extruded outer surface, encased, was what they claimed as their unique patentable invention.
Okay, so Dura-Line has their Dura-Track product and their patent. Then they see what Jain Irrigation is doing.
Right. In April 2013, they filed a lawsuit.
Alleging infringement.
Yes. They claimed Jain Irrigation's pipes, the ones called B-Sure and Jain Instatracer pipes, used the essential features of their patent, IN 1997-22. And also infringed a related design registration they had.
But Jain Irrigation didn't just roll over. They fought back.
Oh, yeah. They denied infringement, obviously, but they also filed a counterclaim. They asked the court to just revoke Dura-Line's patent altogether.
Basically saying, your patent isn't valid anyway.
Exactly. They threw the book at it, using grounds from Section 64 of the Indian Patents Act. Lack of novelty, meaning it wasn't new. Lack of inventive step, meaning it was obvious to an expert.
Yeah.
They also argued the patent didn't describe the invention well enough in sufficient disclosure and that the claims weren't clearly defined.
Wow.
And they even accused Dura-Line of committing fraud on the patent office when they applied for the patent.
So they really went for it. The court then had to frame the key issues, right? Ownership, infringement of patent, infringement of design, fraud, patent revocation.
Yep, all laid out in October 2016. And logically, the court had to start with the validity question.
Makes sense. If the patent's invalid, infringement doesn't matter.
Correct. So, first hurdle. Did Dura-Line actually own the patent and design?
Was that disputed?
Jain Irrigation sort of challenged it.
Yeah.
But the court looked at the registration certificates and said, yeah, Dura-Line owns them. That part was settled pretty quickly.
Okay, ownership confirmed. Then the big one, novelty. Was Dura-Line's invention actually new back in 2003? Jain Irrigation said no.
That's right. They brought out what's called prior art documents, patents, publications that existed before Dura-Line filed.
And the test for novelty is tough, isn't it?
Very tough. The court asks, does any single one of these prior art documents disclose every single element of Dura-Line's Claim 1? You can't combine bits from document A and bits from document B to attack novelty. That's called mosaicing, and it's not allowed here.
So one document has to show the whole invention.
Pretty much. The court looked closely at the main prior art Jain Irrigation relied on.
Like what?
Well, there was a U.S. patent application, DW21, but the court found it talked about embedding a wire inside the pipe wall.
Not co-extruded on the outside.
Exactly. And interestingly, the court pointed out that this prior art even seemed to teach away from putting things on the outside, mentioning issues with external ribs causing connection problems.
Wow, so it actually supported Dura-Line's argument that their approach was different.
In a way, yes. It showed that putting it on the outside wasn't the obvious thing to do, maybe even discouraged. So DW21 didn't kill the novelty.
What else did they look at? Another U.S. patent, DW22.
Yeah, that one showed a wire put in a groove on the outside, but it was sealed in with filler after the pipe was made. A separate step.
Again, not the co-extrusion process claimed by Dura-Line.
Right. The court saw that as a different manufacturing method and a different final structure. So also not a novelty destroyer.
Okay, there was also this NHAI tender document, DW23, National Highways Authority of India. It mentioned needing co-extruded tracer wires on telecom ducts. That sounds pretty close.
It does sound close, but the court drew a fine line. They said, look, this is just a specification, a wish list of what was needed for telecom ducts. It wasn't a technical guide showing how to do it or proving it was done that way for fluid pipes on the outer surface for leak detection.
Not enough detail.
Lacked the enabling technical detail for Dura-Line's specific invention. The court went through other documents too, like one about leak detection using special cables inside the pipe and another using fabric under the pipe. None matched Dura-Line's Claim 1 exactly.
So the conclusion on novelty.
None of the prior art documents, taken individually, disclosed all the essential features of Claim 1. The novelty challenge failed. Dura-Line's invention was officially new.
Okay, step one done. But new doesn't automatically mean inventive, right? The next challenge was lack of inventive step or obviousness.
Correct. Section 64(1)(f). This is where Jain Irrigation could try to combine different pieces of prior art.
Mosaicing is allowed here.
Yes. If you can argue that it would have been obvious for a person skilled in the art, the PSA, your hypothetical average expert in pipe technology back in 2003, to combine that existing knowledge to arrive at Dura-Line's invention.
So the question is, even if all the bits existed somewhere, tracer wires, co-extrusion, fluid pipes, location problems, would putting them together in this specific way have been obvious?
Exactly. Would the PSA, looking at the prior art, have been motivated or prompted to create this setup? Fluid pipe, co-extruded outer tracer encased for traceability and leak detection.
And what did the court think?
They applied a standard test, looking at the inventive concept, the common knowledge, the differences from prior art. And they found, no, it wasn't obvious.
No.
Well, like we discussed, some prior art actually taught away from external placement. Others were for different fields like telecom, not fluid pipes dealing with leakage. Another used a different multi-step manufacturing process.
So there wasn't a clear path or suggestion in the existing literature telling an expert, hey, you should try co-extruding a wire on the outside of a water pipe like this.
Precisely. The court couldn't see a common thread or a logical reason why a PSA would have combined those specific disparate pieces of prior art to land on Dura-Line's solution. They were also careful to avoid hindsight bias.
Judging it based on knowing the answer now.
Right. Just because it looks simple now doesn't mean it was obvious back then without the benefit of Dura-Line's disclosure.
So the inventive step challenge also failed.
Yes. The court concluded the invention involved an inventive step. It was not obvious.
Okay, 2 major validity hurdles cleared. What about the other challenges? Insufficient disclosure, unclear claims.
Jain Irrigation argued the patent didn't explain how to do the co-extrusion well enough or give enough detail about performance with different fluids, things like that.
Basically, you didn't give us a complete instruction manual.
Sort of, but the court pushed back. They said a patent doesn't need to be an exhaustive textbook. It just needs to enable that person skilled in the art using their existing knowledge to replicate the invention without undue experimentation.
And co-extrusion itself was already a known technique.
Yes, the patent didn't need to reteach the basics of co-extrusion, and figuring out how it works with specific fluids or conditions, that's routine work for someone in the field, not undue experimentation.
The court also noticed an inconsistency in Jain Irrigation's argument, right?
Yeah, they pointed out that Jain was criticizing Dura-Line for lack of detail on co-extrusion, while at the same time relying on that NHAI tender document, which also lacked such detail as prior art.
Can't have it both ways.
Pretty much. The court found the patent description was sufficient, and the claims were clear enough, so those objections were rejected too.
Leaving only the fraud allegation. That sounds serious.
It is. Section 64 in Armin. It requires proving Dura-Line deliberately misled the patent office or intentionally withheld crucial information. A very high bar to meet.
And did Jain Irrigation meet it?
No. The court found they didn't provide specific proof of any instance where Dura-Line willfully deceived the patent office or knowingly hid relevant prior art. The arguments seemed to just rehash the insufficient disclosure points.
So that failed too.
Yes, the fraud argument was rejected.
Okay, so after all that, the court went through every single challenge Jain Irrigation raised.
Novelty, inventive step, sufficiency, clarity, fraud.
And rejected all of them. Meaning Dura-Line's patent in 1919-722 was declared valid.
Absolutely. The counterclaim for revocation failed completely.
All right, so the patent stands. Now we get to the next big question. Did Jain Irrigation actually infringe that valid patent?
Yes, that was issue 3. Dura-Line argued Jain's Be Sure and Jain Insta-Tracer pipes had all the essential features of Claim 1. They showed product comparisons and, importantly, Jain Irrigation's own marketing stuff.
And Jain's defense, besides trying to invalidate the patent, what did they say about their own product?
They claimed they were just using conventional tech, and crucially, they insisted they used a different manufacturing process. Not simultaneous co-extrusion, but a two-step process. Make the pipe, then stick the cable on later.
Trying to distinguish based on how it was made.
Exactly. They also tried that circular argument again. If our product infringes your patent, it must also infringe the prior art, so your patent must be invalid over that prior art.
How did the court handle the manufacturing process difference? Did that matter?
This is where the court focused on substance over form. Since Claim 1 was for a product, the pipe assembly itself, the court looked primarily at the features of Jain Irrigation's final product, not necessarily the exact steps they took to make it.
So what did the final Jain product look like compared to the patent claim?
Well, the killer evidence seemed to be Jain Irrigation's own brochures and technical documents.
What did they say?
They actually described their Be Sure and Jain Insta-Tracer pipes as having a co-extruded cable.
Ouch. Using the exact key term from Dura-Line's patent claim in their own marketing.
Yes. Even though their witness later testified about a two-step process, the court found that testimony wasn't convincingly proven and was directly contradicted by their own literature, calling the product co-extruded.
So the court felt the final product, with the cable integrated and encased on the outside, matched the patent claim, regardless of the exact timing of the extrusion.
That seems to be the reasoning. Whether it was perfectly simultaneous or slightly sequential, the end result, as described by Jain themselves, embodied the key features of Claim 1. The substance was the same.
And the argument about infringing the prior art if they infringed the patent.
The court shut that down again. They said infringement and validity are separate questions. They'd already found Dura-Line's patent was valid over the prior art because it claimed a specific, non-obvious combination. Just because Jain's product might also look a bit like some prior art didn't get them off the hook for infringing Dura-Line's specific, valid claims if their product also included those claimed features.
So the verdict on patent infringement.
The court found that Jain Irrigation's products did incorporate the essential elements of Claim 1. Therefore, Jain Irrigation Systems Ltd. had infringed Dura-Line's patent in N 1997-22.
Okay, big win for Dura-Line on the patent front, valid and infringed. But what about the design registration? They claimed infringement there too.
Right, design registration number 192665 for a detectable pipe. But they didn't win on this one.
Why not? What's different about design protection?
Design protection in India covers the visual features, shape, pattern, look, and feel judged by the eye. Crucially, it cannot protect features that are purely functional or dictated by the technical job the article has to do.
And Jain argued Dura-Line's design was really about function.
Yes, they argued Dura-Line was basically trying to get design protection for the functional concept of having a tracer wire, not a truly unique visual appearance.
Did the court agree?
They did. They noted that when Dura-Line's own witness was asked to describe the design details, he included things like polymer pipe, co-extruded tracer wire, encased in polymer. These are technical functional elements.
So they were describing the invention's function, not just its look.
Exactly. That suggested they were trying to protect function via design law, which isn't allowed. The court also found other problems.
Like what?
The pictures or representations of the design that Dura-Line used in court didn't seem to perfectly match what was officially registered on the design certificate. That's a problem.
Okay.
And just looking at the visual comparison, the court wasn't convinced that Jain Irrigation's pipe looked deceptively similar to Dura-Line's registered design. Dura-Line's registered design apparently showed a simple straight line for the cable, while Jain's might have had a different look, maybe wavy.
So the design claim failed because it was trying to protect function, the evidence didn't quite match the registration, and visually they weren't considered deceptively similar.
Pretty much sums it up. Functional features, lack of clear visual similarity to the registered design, no design infringement.
Okay, so let's recap the final scoreboard. Dura-Line's patent. Valid and infringed by Jain Irrigation.
Check.
Dura-Line's design, not infringed.
Check.
So what does this mean practically for Dura-Line? What relief did they get?
Well, there's a slight twist because of timing.
Mm-hmm.
The patent actually expired, ran its full course in July 2023, right before the court's final judgment.
Ah, so they couldn't get an injunction to stop Jain Irrigation from making the pipes now.
Exactly. No injunction stopping future sales and no order for destruction of existing stock because the patent rights that were infringed no longer exist.
But what about all the infringement that happened before it expired for years?
That's where Dura-Line still gets relief. They're entitled to compensation for the past infringement. The court ordered Jain Irrigation to provide a rendition of accounts.
Rendition of accounts sounds like opening the books.
That's exactly what it is. Jain Irrigation has to calculate and disclose all the profits they made from selling the infringing Be Sure and Jain Instatracer pipes during the period the patent was valid and being infringed.
Which period is that?
From when the suit was filed effectively, April 2013, right up until the patent expired in July 2023. A decade's worth of potentially infringing sales.
Wow. That could be a very significant amount of money.
It absolutely could be. The court appointed a local commissioner, usually retired judge, to oversee this whole accounting process and figure out the exact amount Jain owes Dura-Line.
So even an expired patent can still have teeth regarding past actions.
Definitely. The court also issued a certificate of validity for the patent, officially recognizing it withstood the legal challenge.
And what about the costs of this huge legal battle? Who pays?
The court ordered Jain Irrigation to pay Dura-Line's full commercial costs. They cited precedent, saying that in commercial cases, the loser generally pays the winner's realistic costs.
To discourage weak arguments.
Partly, yes. And just to make the winner whole. Given the decade-long fight and Jain's complete failure to invalidate the patent, the court felt they should bear Dura-Line's costs, including the commissioner's fees.
So looking back at this whole case, what are the big takeaways for you? This Dura-Line versus Jain Irrigation saga seems like a real IP masterclass.
It really is. It hammers home just how critical the specific wording of your patent claims is. That distinction embedded within versus co-extruded on the outer surface encased wasn't just semantics. It was the key to proving novelty and non-obviousness. Precision matters hugely.
And it really highlights the difference between a product claim and maybe a process claim. Infringement here turned on the final product having the claimed features, maybe less so on the exact manufacturing steps Jain used. That substance over form idea.
Absolutely.
Yeah.
And it starkly shows the limits of design law. It's about the look, the visual appeal. You just can't use it to protect the underlying technical function, no matter how clever that function is. You need a patent for that.
And finally, the money. It's a powerful reminder that even if your patent expires during litigation, the infringer can still be on the hook for potentially massive damages based on their profits from years of past infringement.
It really paints a picture of how complex, technical, and financially impactful these patent and design disputes can be.
Which leaves us with a final thought. Given how incredibly detailed the court's analysis was comparing Dura-Line's specific configuration against every piece of prior art, focusing on that co-extruded outer cable, what does this case really tell you about the level of technical depth and rigorous claim drafting needed not just to get a patent granted, but to successfully defend it against determined challengers in technically complex fields? Something for you to consider in your own context.